golden factory over here. So like what we did with Baker, what we're doing is we're applying factors, we're analyzing factors to help us determine whether the applicable standard of review is reasonableness or correctness, right? The reasonableness, blue big circle, or red narrow circle, correctness. And we're going to use arrows again. This course should be called Administrative Arrow Law, or something like that. Because, yeah, they come into play again, and we're following the lead of the Supreme Court. So here are the 4 factors. Is there a prohibitive clause? Yes or no, and how strong is it? Back to this. Prohibitive clause. We learned a bit about prohibitive clauses, what they are. They're strong ones, weak ones. What's the exact opposite of a prohibitive clause?
The clause that says that you can appeal to the court.
Yeah.
The decision of the
An appeal clause in the statute is the opposite. Because what is the legislature saying there? With the prohibitive clause, the legislature is saying hands off our DM, right? With an appeal, the legislature is saying basically hands off. Or we welcome you, courts, we welcome you to intervene, to review our DM's decision, to interfere in a way, or to examine the DM's decision closely. In other words, it signals correctness. It signals correctness. And all of these factors, using our arrows, are going to signal correctness or reasonableness. More deference, less deference. More respect, less respect. That's the dichotomy that we work with. Okay, we're going to find out later on, I think next week, in much more detail, how each of these factors work, what they mean. Just kind of, again, tonight, more of an introduction of what the factors are and what language we use in doing a substantive review analysis. So prohibitive clause, purpose of the tribunal, the enabling legislation. We'll explain that later. The nature of the question, number 3, really, really important one. Nature of the question. And that's where you get into this whole idea of a question of law, a question of fact, a question of mixed fact and law, a question of discretion, a question of jurisdiction. A constitutional question. It's number 3, really important. And number 4, expertise of the tribunal. Of course, that's an important question as well. An important factor. Expertise of the tribunal. Because we know that a lot of what we're talking about here is how much expertise does this tribunal have? Does this DM have in the subject matter? Compared to who?
The court.
Compared to the court. Compared to the judge. How much expertise does this DM have? A lot or a little or somewhere in between? This is kind of a wrap-up slide, which we've really already covered. Okay, we're now getting a little bit deeper into the standard of review analysis and substantive review. So we're going to look at some more specific questions, concepts, as listed here. So digging in a little bit on the idea of expertise. So, of course, the critical part of this SOR analysis is expertise. Dunsmuir explains that to us. And the evolving case law from the Supreme Court establishes for us that expertise can attract deference even when there is no privative clause, right? Privative clause, sure, it's important, but it's not as important as expertise. Even in the face of a question of law. Again, something the courts have trouble with, because they have a hard time accepting that on a question of law, a DM might know more than they do. But they have to, they're told to show that respect in the right case. So this idea of respect for the relative expertise held by the DM versus the court. Okay, a little bit about questions of law. So in Dunsmuir, they talked about questions of law generally being something that the courts should show respect to the DM on. But they do say, well, there's a certain kind of question of law where the court should not show deference. And don't worry, we're going to come back to this. But this idea of a question of general law of central importance to the legal system as a whole and outside the tribunal's specialized area of expertise, that kind of question of law is always going to suggest correctness, not reasonableness. But you can see how specific that is. DMs don't often deal with these kinds of questions, but when they do, we know that they're probably going to end up in the correctness zone. And the courts are probably going to show no deference and they're going to apply correctness. Because as the court said in Dunsmuir, these kinds of questions are too important to be left to a DM. And the courts have to decide what's right and what's wrong. What's correct and what's incorrect. Okay, discretion. Another kind of, or a category of question that a DM deals with. Discretion. What is discretion? What's a discretionary decision? Well, we say here, a discretionary decision is a decision where the law does not dictate a specific outcome, or the DM is given a choice of options within a statutorily imposed set of boundaries. So a good example might be a remedy. So let's say, let's look at the jockey case, and let's say that the DM in that case has discretion as to what kind of penalty to impose. Okay, there's a finding that the jockey committed an offense or broke the rules. So what's the penalty going to be? And we've all seen clauses like this. Well, the penalty could range anywhere from a reprimand to a suspension, or complete termination, removal of the license. The suspension can be of any time period. So the DM says, oh, I'm going to suspend this jockey for 2 years, something like that. That would be discretionary, right? Because they can choose. There isn't a right or wrong answer. They can choose. The DM can choose in their discretion what the applicable penalty should be. That's a classic example of a discretionary decision. But we have to think about this whenever we see a discretionary decision being made, that there's this concept called abuse of discretion. And this kind of sums up what abuse of discretion is. And if there's abuse of discretion, that's considered an error of law. Correctness is the appropriate standard of review, and that would be a fatal error of law if there was an abuse of discretion, kind of an automatic fatal error of law. So how does a DM abuse discretion? Well, we have the Roncarelli case, where the DM, the minister, used the power to achieve a purpose outside of the grant, to achieve a purpose that was not envisioned by the statute, to carry out a personal vendetta, for example. So we call that an abuse of discretion. And this second bullet is really important here too, this sub-bullet, where the DM takes into account factors that are not relevant or fail to take into account relevant factors. And we know that from Baker. Where irrelevant factors were taken into account. So even though normally the court says, we're going to approach a DM's decision on a question of discretion with deference, reasonableness, we're always going to find that use of discretion and abuse of discretion, like as described there, is going to be fatal, be a fatal error of discretion. Okay. So Baker, Baker was the old way of doing things, but it's actually not very different from the way we do things now in terms of the standard of review analysis. And how did that play out in Baker on the factors that we've just been introduced to? They looked at the statute, they said, well, there's no prohibitive clause, so that doesn't really signal correctness or reasonableness. Basically, a sideways error. On expertise, the court said, well, we know that the Minister of Immigration has expertise, by definition, has expertise on immigration matters. So it would be arrow up, right? Pointing towards reasonableness, pointing towards deference. That's what arrow up is what it means in the standard of review analysis. They say that, what kind of decision are we talking about? Well, it's a discretionary decision. It involves considerable choice on the part of the minister, so deference is owed. Then they also add this piece, but it also relates to rights and interests of individuals. We'll park that for now. So we'll say it's a discretionary decision, so generally arrow up towards more deference, towards reasonableness. And then they say, the issue requires application of facts. So this is findings of fact and applying facts to the law. Generally speaking, those kinds of decisions attract deference, so arrow up. So their conclusion there in Baker was the standard of review is reasonableness. We have this simpliciter because that's a term that we used back then. Nowadays it would just be reasonableness. And it would probably still be decided the same way today. That the standard of review for that decision in Baker would be reasonableness. Okay? Because the factors pointed either nowhere, sideways, or up towards reasonableness. But remember, the court can always say, yes, the standard of review is reasonableness, but this decision was unreasonable. Right? So just because the standard of review is reasonableness doesn't mean the decision is okay. They just have to use the language and say it's reasonable or unreasonable. Here, they had no trouble saying that the decision was unreasonable. And they use this phrase that you can kind of forget about. It does not stand up to a somewhat probing examination. That's an old way of talking about reasonableness. We're going to learn more about the new way. So a couple of errors that they cited, they say, well, the DM here did not consider the best interest of the child. And remember, in just discretionary decision, when you fail to take into account a relevant factor, that's going to be fatal. That's going to be unreasonable. And the DM did exactly that. Made exactly that error. Failed to consider a relevant factor, the best interest of the child. Then they say, also the decision showed it was inconsistent with the values underlying the grant of the discretion. Just another way of saying the discretion was in error, exercised in error. Okay, abuse of discretion, we mentioned Roncarelli before. And we say what we learned from Roncarelli is that no legislative act can be taken to contemplate an unlimited arbitrary power exercisable for any purpose. So just because a DM is given a broad discretion doesn't mean they can abuse that and use it for any purpose to, attack an enemy or gain personally or something like that. Carry out a personal vendetta, these kinds of things. Of course, the court says, yeah, discretion is broad, but it's not that broad. It doesn't include. So a DM can't say, oh, you can't touch me because I have discretion. I can do whatever I want for whatever reason I want. Courts can't touch me. Courts say, no, we're not going to accept that. We're going to look at how you exercise your discretion and the purpose for which you exercise your discretion. And if you do so improperly, we're not going to let that stand. And that's what happened in Roncarelli. So we ask here, in the case, the judge says this: could an applicant be refused a permit because he had been born in another province or because of the color of his hair? The ordinary language of the legislature cannot be so distorted. You can't exercise discretion for any reason you want. It's broad, but it's not that broad. Okay. Remember, a lot of the cases that we look at and the decisions by DMs that we look at are discretionary decisions, because a lot of DMs have discretionary power to kind of do what they want with people. Because the legislature empowers them to do that and tells them they can do that. Again, it gives them a broad discretion. But we now know that there are limits. Tough to overturn a discretionary decision, right? We know that. If our jockey was suspended for 2 years and you said, oh, that's too long, it should have been 1 year, oh boy, you're going to have a hard time convincing the court to interfere with that because there's a broad discretion. You would have to show some kind of error in how they arrived at the 2 years. But you're going to have a really tough time on that. But what are you going to say? Our jockey friend had his license revoked for life. What are you going to argue there? It's discretionary. They can do what they want.
The penalty itself is too harsh. So it's not just about the term of the suspension. So here, maybe they could have chosen a different penalty.
Okay, but do better than that. I'm the judge. Convince me. It's too harsh. Okay. So you say, well, the DM didn't think it was too harsh. What language are you going to use to convince me as a judge to interfere with that? Why should I interfere? It's reasonableness. I'm deferring to this DM. What's a word that we're going to pull out? The U word.
Unreasonable.
It's unreasonable. It's unreasonable. Yeah, you're going to say 1 year, 2 year, 2 years, 3 years, maybe even 5 years. It's a long time. But life? No. Lifetime ban? Are you kidding? That's unreasonable, is what you're going to say. Convince me, right? That's outside the range of reasonableness. It was a minor, transgression. Sure, my client exercised poor judgment, but really, you're going to take away my client's livelihood? Suspend him for life? That's just unreasonable, you're going to say. That is unreasonable. A time-limited suspension of a reasonable number of years, fine. But life is clearly unreasonable, and that's where you're going to have to go, because you're not going to be able to get correctness. Right? You're not going to be able to get correctness. The courts are going to say this is reasonableness, and there's more than one acceptable answer. And you're going to say that's true, but a lifetime ban is unreasonable. And you'll back that up. But that's what you have to argue, and that's the terminology you have to use. But we're going to give you more tools to back that up and to give that more power and more weight, to be persuasive for the court on judicial review. The Halifax case. I can't remember why this was important. Not that important. Again, pursuing this idea of discretionary decisions and reasonableness, deference. I don't think there's much more to say about the Halifax case. Suresh is an interesting, fairly important case. There were two discretionary decisions that had to be made by the DM. Was Mr. Suresh a danger to national security? And did Mr. Suresh face a substantial risk upon return to Sri Lanka? The court applies a pragmatic and functional approach, which was the old way of doing it back in 2002. And they reached the deferential standard of, back then, what was called patently unreasonable. And they apply that, and they actually do say that these discretionary decisions were unreasonable. So that's a successful attack on a discretionary decision. So, and this helps us a little bit here. So the court does what it should do and says, well, did the DM consider all the relevant factors? The court can't reweigh the factors and say, oh, this is how we would have weighed the factors. They can't. They can only say, did the DM consider them, yes or no? If they did, we can't interfere. But we can interfere or intervene if the decision is not supported by evidence or fails to consider relevant factors. So these are our keys to be able to overturn a discretionary decision. So in the lifetime ban, with our jockey, we're going to look closely and say, did the DM in that case consider all the relevant factors? And if you can find a factor, one or more factors, that were relevant, that the DM didn't consider in their reasons, you've got a good case, you've got a solid case of a failure to consider relevant factors. Because that's fatal, right? Remember, that's fatal. But to simply say, well, a lifetime ban is excessive, that's a hard thing, is unreasonable, that's a hard thing to prove. So you look for those fatal errors in exercise of discretion. Agrera is an example of a failed attack on an exercise of discretion. The court ends up saying that the minister's decision in that case was reasonable. And it's simply a case of the court saying, we're satisfied the minister considered all of the relevant factors in exercising discretion, and we have no basis to intervene because the DM did their job appropriately by considering all the relevant factors. Again, the court says, we're not going to go in and reweigh those factors. That's not our job. That's the DM's job. just not going to do it. So we leave it alone, and they stay out of that decision. They don't interfere. Okay. Prerogative powers. This is a weird one. It doesn't come up very often, but it's something that you need to be aware of. There's a thing called prerogative powers in administrative law, which are kind of historical, traditional powers bestowed on government decision makers. So we have the Council of Civil Service Unions case from the UK, 1985, the House of Lords. A decision was made to disallow civil servants from being members of the union. The minister made that decision pursuant to a prerogative power. This decision is challenged in court, and the government says, aha, courts, you can't review this decision because it's prerogative. It's beyond court review. Actually, that argument ended up being unsuccessful, but we know from this case that there are going to be certain situations where it really is a valid exercise of prerogative power where the courts will not intervene. And I'm going to take you to a Canadian case where that's exactly what happened. And we learn here that in that last bullet point, some decisions will remain immune from review by the courts. Things like granting of an honor. So what's the Canadian honor? I'm trying to remember now. The Order of Canada, you might have heard about that. Yep. Where they bestow an honor upon citizens who have done something outstanding or remarkable. Well, you can't review that. Or I guess the failure to grant an honor. Can't go to courts and challenge that. The making of a treaty. So the government has a prerogative power to enter into a treaty with another country or sign on to a UN declaration or something like that. These are prerogative powers. So if we say, oh, the government just signed on to this treaty and we don't like it, we're going to court, what's the court going to say? No, you don't belong here. There's nothing we, the court, can do about this because this is a prerogative power where we have no business interfering. So you will fail on that point. Dissolving Parliament, a decision to dissolve Parliament. The appointment of a minister. These are all examples of prerogative powers that cannot be reviewed by a court. The prerogative of mercy, granting a criminal pardon. There's another funny one that is more close to home for us, which is hard to believe, but anybody know? What's that document that we all like to get? So we can go on vacation. Yeah. So weird, like granting of a passport is considered a prerogative power. You can't review it in court. Okay. This case is great. I love talking about this case. Some of you might know about it. Conrad Black. You guys know who Conrad Black is? So I always laugh. Conrad Black wants to be appointed a peer in the United Kingdom, which would allow him to sit in the House of Lords. And it looked like he was going to get this, but he alleged that the Prime Minister at the time, Jean Chrétien, intervened with the Queen to oppose his appointment, which I think he did. So the court ends up saying, so Black brings a court challenge and says this was an improper abuse of power by the Prime Minister, and went to the Ontario Court of Appeal. And the Ontario Court of Appeal says that giving advice to the Queen or communicating to her Canada's policy on the conferral of an honor on a Canadian citizen is not justiciable. It is not reviewable in the courts. So poor Conrad Black had to, anybody know what happened? Yeah. And he became Lord Black of Cross Harbour. Good for him. No longer a Canadian citizen.
He then went to jail too after that thing. So.
It did end up going to jail, that's right, in the US. Yeah, that's right. For a while. Okay, we've actually come to the end of our slides. Really, we're just a little bit into this topic. We're going to get deeper. We're going to get more practical as far as giving you the tools to analyze the problem, to determine what is the applicable standard of review, which is going to be your challenge. You're for sure going to be tested on it at some point. Well, one point. At one point. Yeah. So, and I am going to give you an outline like I did for procedural fairness, like a framework to help you, to guide you through that process so you know kind of the key points and how to assess, how to determine the standard of review. We're going to take up at least one, probably more, questions like in the NCA or maybe other questions. So we, as a group, can work through a problem and figure out, what's the best way to approach the 4 factors in the standard of review analysis, assess the factors, and then apply it, right? Because we remember, and people forget, they think the whole game is to figure out what's the standard of review. And it's not, because you're not done yet, right? You have to then apply it to your situation. So if it's reasonableness or correctness, how do you apply that to your problem? Okay? And we need to use certain tools to apply that properly. That courts themselves use, and the Supreme Court of Canada has told us how do you apply correctness to a problem, and how do you apply reasonableness to a problem. They're different, and they require their own, their own language to apply. And the other thing we're going to do, because it's really important, we could do it tonight, do it later. A problem that helps us figure out what kind of question is the DM dealing with. Because this becomes really, really important. What kind of question did the DM answer? It could be more than one. But let's say it's one. Was it a question of law? Was it a question of fact? Was it a question of mixed fact and law? Was it a question of discretion? We talked a lot today about discretion, because that's its own kind of question. Was it a constitutional question? And we're going to delve into all of those and how you sort out what is what in terms of what question did the DM answer, because we have to categorize the question, the nature of the question, because that is going to really very strongly point to what standard of review is actually applicable to that question. Okay, and another point I will make is that often DMs make they answer multiple questions. For example, in the jockey case, did the jockey break the rules, yes or no? There could be a whole hearing on did the jockey break the rules, yes or no? Allegedly cheated in a race, right? That's our scenario. So what happens there? There's going to be findings of fact, findings of law, findings of mixed fact and law. Sometimes those are hard to differentiate. But the question will be, did the jockey break the rules? And then, if the answer to that is yes, what should the penalty be for the jockey? Maybe nothing, maybe a reprimand, suspension, 1 year, 2 years, 3 years, 5 years, or a lifetime ban. And what kind of decision did we say that was? Discretionary, yeah. So that one's easier. So my point being that you have to figure out the standard of review for each question, right? Because it could be correctness for one and reasonableness for another. And this is why when you read some of these cases, they say, well, the standard of review for this, for question 1 is reasonableness. But the standard of review for question 2 is correctness. And the standard of review for question 3 is reasonableness. So you do break it down into each question that the DM answered. Okay? So you have to keep that in mind, because you have different standards of review and different ways of analyzing that. But remember, if you're successful on one of them, the whole thing gets quashed, right? The whole thing will get quashed and sent back for a new hearing. If you successfully argue that the DM made either an unreasonable or incorrect decision. It could be on, did the jockey break the rules, or was the penalty against the jockey in an error? Right? Okay, so we have to keep that in mind, question by question. Again, don't worry, this is introductory. We're going to go deeper into it. We're going to look at more cases, so you'll become more comfortable with how the standard of review analysis works. And you get to the answer of reasonableness or correctness, and then, of course, how you apply it to your specific situation. Okay, any questions? A lot of people have questions about the assignment. Let me see if I can answer all the questions. Okay, so first of all, don't spend a lot of time on the background, right? I know the background, I know the case. Don't retell me all the facts, then this happened, then that happened. I don't need that. Give me a nutshell. Basically, poor Mr. Samidas is trying to pass his exams, and there was this incident, and it was found that he cheated and he was suspended for 2 years, I think it was. That's basically all you need to do. Give me some of the facts, so tell me a little bit of a story, but keep it really short. Kind of like an introduction, yeah. So you're not going to get a lot of credit for that, but don't waste time on a long explanation of the facts. Assume I basically know them, and you don't need to repeat everything that happened. You could write 3 pages on that, and you'll be wasting time. So do a pretty brief introduction, then get into it, and then say, okay, and also don't do, well, does procedural fairness apply a common law? I know I told you you've got to do that, but in this case, I'm asking you to skip that and go direct to Baker. Okay, we're going to assume procedural fairness applies. Probably does, right? But I don't need you to tell me that. You can just say, now, okay, I've told you the background, now I'm going to tell you what I think in terms of how much procedural fairness the DM owes to poor Mr. T. Low, medium, or high?
2 questions I ask first, which procedural fairness problem.
Well, you pick an issue, yeah.
I know, but do we speak about that first then?
You don't have to do it in that order. I know I said it in that order, but you could maybe do it later. The order's not that critical. Okay, but you're going to have to pick an issue. Because, sorry, PF issue. You have to pick one. There could be multiple issues, right? Yes. You need to pick one. It could be, right to an oral hearing. That's your issue. So I don't need you to talk about reasons. I don't need you to talk about the other problems that might have been there. Pick one and run with that. Do your Baker analysis, and remember, Baker analysis is really not, okay, the single biggest mistake people make is in their Baker analysis, when they go through the factors, they start talking about, and Mr. Samidas was told this, and he was promised that, and he didn't get a chance to, don't say any of that, right? You're just analyzing this DM. There's actually 2 DMs. You're analyzing the DM, and you're telling me, based on what you know about the DM, which is not a whole lot, you know some, based on what you know about the DM, how much fairness is owed, low, medium, or high, and where the arrows go. So the most important part of the assignment is your 1, 2, 3, 4, 5 factors, and what you say about them. So don't just give me a conclusion. Well, factor number 1 says doesn't look like a court. I think it looks like a court. Arrow out. I would love that. Easy to read, but it's not good. It's not good enough. Why does it look like a court? What makes it not look like a court? What's missing? That's factor 1. So, give me that. That's where the real value is in those factors. Okay? Then, you do all the factors. You have your arrows. You say, I think it's medium. Don't stop there. I think it's medium because. Give me something. Persuade me that you're right, that it is medium, or it is low, or it is high. It's not so much do you get the right low, medium, or high, but that you back it up. You back it up. Convince me that you're right. Then you apply it to your one issue, right? That's the sequence. Then you apply it to your one issue. Oral hearing, reasons, evidence, whatever it may be. Notice. Just the one issue, apply it to that. There's only so much that you're going to be able to say, but say something, do your best. To say something as to why, hey, I think he was denied procedural fairness, he should have been given that right. Or, I'm totally fine if you say, no, he got enough fairness. He wasn't entitled to, let's say, an oral hearing. He wasn't entitled to that. He didn't get it, he wasn't entitled to that. That's fine. Either way, if you back it up, you justify it, you're good.
So we don't have
Because people are going to disagree on this.
we don't have to worry much about the underwritten questions then. As long as we speak about
Not so much, yeah. Spend most of your time, put your effort into the factors. And the factors, and then applying your low, medium, or high to the procedural fairness point. Right? It shouldn't be hard to do. You're going to do a better job than the court did because they didn't bother doing a Baker analysis they should have. You're going to show the court why you're smarter than they are. You may agree or disagree with them on what they said. So that's really the key. So again, I want to re-emphasize, in factors 1, 2, 3, 4, 5, don't talk about Mr. T. What he got or didn't get. That comes after. Because I've done this, it's like my 5th year teaching. It's by far the most common mistake. So I want you all to steer around that mistake. Okay, and headings are good and important, and arrows are good and important. Headings and arrows. They help me follow your story. I'm trying to think if I got any other questions. I think that's basically it. Yeah, again, don't retell me the story, right? Don't retell me the story. I basically know it. You can do a really short recap of what happened. That's it. You're just wasting time. Any other questions?
Can I use PI instead of procedure fairness?
Yeah, absolutely. You can use PF. I'm good with that. Short form, because that's one of those terms I said for short forms we can use. We all know what we mean by PF. We all know what we mean by DM. It's another one. Just makes it a little easier. It's up to you. Are there any other acronyms? I can't think of them right now. On the PF side, I think that's it. Other questions? No? Oh, kind of early tonight, but it was a lighter night. So, thank you. and we are going to see you again next Wednesday. Happy Halloween. Chocolate graciously accepted.